I want to talk to you about two types of drug crimes: possession and possession with the intent to deliver. Now, simple possession is a misdemeanor charge, while possession with intent to deliver is a felony charge. There's a major difference in these two types of charges. With a simple possession charge, you are facing possibly probation or at most a county type sentence. With a possession with intent to deliver charge, that's a felony and you're facing possibly a state sentence. Now, with a simple possession charge, the prosecution has to show that you somehow possess the item, whether it be constructively or actually. Now, in previous videos, I spoke to you about actual versus constructive possession. So if you don't understand that concept, please watch the previous video. But in a simple possession charge, the prosecution only has to prove that somehow you had the item on you or it was in your area of immediate control. Now, with a possession with intent to deliver charge, commonly called a PWID or a PWID, the prosecution has to show that you not only possess the item, but in addition to possessing it, you intending it on either selling it or distributing it. Now, with possession with intent to deliver, the prosecution must show that you actually possess the item and you intended on either selling it or distributing it to someone else. In these situations, the prosecution will commonly use observed transactions by a police officer. Now, there are situations where the prosecution cannot present observed transactions, and they will attempt to prove you guilty beyond a reasonable doubt by some other evidence, circumstantial evidence, like the amount of drugs that you had on you, the amount of cash you had on you, the way the drugs were packaged. And they can do all this to an expert witness who can testify that based on that person's experience and training, you intended on selling or delivering these drugs to someone else based on the way the items were carried on you or the vehicle that you were traveling in. Now, these two charges sound similar, but they're very different. And it's very important that you discuss the differences with your attorney and that your attorney explain what type of defense he can put up to fight these charges against you.